But welcome to our annual Shapiro lecture. Unfortunately, Max Shapiro's family, Larry and Sue Ellen Cadis, who usually attend these lectures, are out of the country today, but hopefully they'll be with us next year. Even in their absence, so I'd just like to say a couple words about the tradition of the Shapiro lecture for those of you who don't know about it. Max Shapiro graduated from Boston University School of Law in 1933, at a time when you could go direct from high school into law school. And he made a name for himself as an outstanding trial lawyer in New London, Connecticut. Throughout his 60 years as a lawyer, he embraced the role of mentor, inspiring young attorneys through the strength of his character. And he never stopped thinking about a lawyer's duty, particularly because he was president of the Connecticut Trial Lawyers Association. And so he thought a lot about that, and he also cared a lot about his alma mater. And so when he passed away, his son, Andrew Shapiro, who was an alum of the law school from 1977, his daughter Sue Ellen and her husband Larry established a fund for an annual lecture in their father's name at the law school. And the Max M. Shapiro lecture in the Ethics of Trial Advocacy is our principal endowed lectureship, and a fitting tribute, we think, to the memory of a lawyer who was devoted to examining the place of legal ethics in trial advocacy. And those values that Max cherished are represented very well by our speaker today, and I'm delighted to introduce our alumnus, Ken Rose, from the class of 1981. Ken has handled more capital appeals cases than almost any other lawyer in the United States. A recent book, The Last Lawyer, The Fight to Save Death Row Inmates by John Temple, describes him as an idealistic legal genius and tells the story of his decades-long fight to overturn the death sentence of a mentally handicapped man who was wrongfully convicted. The Jones case underscores some of the most difficult issues involved in capital punishment: inadequate defense, mental retardation, mental illness, and sketchy witness testimony. The defendant, Bo Jones, came within 3 days of execution before Ken's advocacy prevailed. Many of our clinical faculty remember Ken well from his days at BU Law when he participated in our clinical programs. Ken was Bob Burdick's student in what was then called the Legal Aid Program and now is the Civil Litigation Program. He worked in the Grove Hall office of Greater Boston Legal Services and was a star even then. After graduation, he has spent much of his life representing defendants in capital cases. He joined Team Defense Project in Atlanta, where he represented clients facing capital punishment. In 1984, he moved to Mississippi, where he directed the Mississippi Capital Defense Resource Center and was one of a handful of lawyers representing inmates sentenced to death in capital post-conviction proceedings. In 1989, he went into private practice in Durham, North Carolina, and continued to represent capital defendants. He became executive director of the Center for Death Penalty Litigation in 1996 and served in that position for 10 years, and he's now a senior staff attorney there. You know, whatever one's position on the death penalty, I think we all believe that it is a basic tenet of justice to ensure that those defendants charged with capital crimes receive a fair trial with the benefit of an adequate defense. And Ken has spent his life ensuring that defendants whose lives are at risk receive the representation they need to fulfill the promise of justice. So we're very proud to recognize the inspiring work that our alum Ken Rose has chosen to do, and please join me in welcoming him.
Thank you to the students and faculty of BU who have invited me to speak. It is a great honor both to speak for the law school and to be chosen to give the Max Shapiro lecture. The establishment and endowment of this lecture is a wonderful way for Mr. Shapiro's children to honor his memory. This is the 30th anniversary of my graduation from Boston University, and I am very proud to be part of this great tradition of community service, and I'm very pleased to be here to give this address. I will talk about some of the people at Boston University Law School who influenced me and influenced my career, and then describe what I believe is landmark legislation passed 2 years ago by the North Carolina legislature called the Racial Justice Act. One of my first memories at BU was a column in the school newspaper by a second-year law student by the name of Phil Gordon. Phil was one of the top students in his class and turned down an automatic spot on BU's law review. Phil wrote that law review was fine if you wanted a career as a law professor or if you wanted to clerk for a judge. But that if you didn't believe, he didn't believe it was necessary or even important if those weren't your goals. Now let me say up front that I never had the opportunity to turn down law review. But I thought that this was exactly the right place for me when I read Phil's words, because he was unafraid to speak truth to power. He was unafraid to speak the truth as he saw it. Of course, around the same time, there was another guy at a law school across the Charles River who did pretty well for himself after being a community organizer and accepting an invitation to join law review. And Barack Obama may disagree with Phil's analysis of the value of law review. I also learned during my first year that BU Law School did not believe in learning just by books. The university administration, faculty, and the law students at BU were not part of the bargaining unit of a strike that was taking place in the university. So they decided to arrange for this strike in order for the law students to have an opportunity to study labor law firsthand. And I spent more times, I think, studying labor law firsthand than I did studying books at that time. Now, I'd like to think my grades at the end of the first year reflected my time marching up and down Commonwealth Avenue and honoring the strike in the picket lines. But the truth was that I did not put in the time and hard work necessary to do well, and I barely passed. Instead of being called the last lawyer by the name John Temple gave to me in his book, I could have been known as the last law student. My second year in law school changed everything. I took the year-long legal services clinical program, as Dean just stated, with Professor Bob Burdick. I was thrilled to be in court and to use the law to help people. I learned to negotiate, to argue motions, and to thrive in that environment. Third year was more of the same. BU law was one of the few places where, if you were lucky, you could take back-to-back clinics in both your second and third years. So I took the criminal defense integrated program with some great professors who are still here, Professor Eva Nielsen and David Rossman. Professor Nielsen guided me to my first job, originally as a VISTA volunteer at Team Defense Project in Atlanta, representing persons on death row, and I am still very grateful to her for that. It is a great credit to the school that is able to attract such talented and dedicated people, and even more importantly, to retain those people. Apart from the clinical programs, there were other BU professors who inspired me then and now. At BU, I had the opportunity to attend lectures by Elie Wiesel, the Nobel Prize laureate and Holocaust survivor. Elie Wiesel lost both parents and a sister in the Nazi death camps. I thought of that when I heard of his October 2010 lecture on capital punishment at Wesleyan University. He spoke especially to family members of murder victims. He encouraged the criminal justice system to focus efforts on the survivors of violent crime so that, in his words, families will not feel cheated by the law. But he said the death penalty was not the solution. He said, I know the pain of those who survive. Believe me, I know. Your wound is open. You are mourning, and how can I not feel the pain of your mourning? But that is not the answer. I took an evidence class taught by Supreme Judicial Court Justice Paul Liakos. Justice Liakos had a system of calling on students at a set time and date so you would know in advance when you would be called on. I missed some of his classes, but I would always be sure to show up when I knew it was my turn to be called on because I enjoyed the interaction with him. Justice Liakos had a great sense of humor, and at one point after he called on me to discuss a case, he remarked that in his class, that in other classes, many students tried to avoid being called on. But in his class, students showed up only when it was their turn. Justice Liakos, who died in 1999, is one of my heroes, and I will discuss in detail his influences on my work. The Massachusetts Supreme Judicial Court, led by Justice Liakos, among others, pioneered independent interpretation of the state constitution in a way that expanded protections of individual rights and the rights of minorities. Just 4 years after the U.S. Supreme Court held the death penalty constitution was applied in Gregg versus Georgia, Justice Liakos participated in a decision by the Massachusetts Supreme Judicial Court holding the death penalty unconstitutional under the state constitution. Still later, he overcame a state constitutional amendment incorporating the death penalty by citing another section of the state constitution to define the death penalty unconstitutional as applied. His decision preventing the use of peremptory strikes in a discriminatory fashion also influenced my work. Defendants and prosecutors are permitted to use a fixed number of peremptory strikes to remove otherwise qualified jurors from jury service, for whatever reason they choose. In 1979, Justice Liakos authored an opinion by the Massachusetts Supreme Judicial Court in Commonwealth versus Soares, where the prosecution had used peremptory strikes to excuse 12 of 13 qualified black jurors, leaving a jury of 11 white persons and 1 black person. Justice Liakos realized that if he simply applied the 14th Amendment as it had been interpreted in 1965 by the United States Supreme Court in Swain versus Alabama, it would require the court to approve without further review the prosecutor's exercise of peremptory challenges in the case. In Swain, the court had said that in order to make an equal protection clause challenge under the 14th Amendment, you must show, in case after case, no matter what the circumstances, no Negroes ever served on pettit juries. This standard was virtually impossible for litigants to meet. Instead of applying Swain, Justice Liakos declared the prosecutor's use of peremptory strikes unconstitutional under the Massachusetts Constitution. He allowed defendants to demonstrate race discrimination by prosecutors' disproportionate juror strikes in a single case, and gave the prosecutors a chance to offer non-racial explanations. In 1986, just 7 years later, in Batson versus Kentucky, the U.S. Supreme Court adopted a framework for consideration of the use of peremptory strikes very similar to the one Justice Liakos had used in Commonwealth versus Soares. Some politicians or scholars might question the means chosen by Justice Liakos to end the death penalty, or to end race discrimination in criminal cases of jury selection. But few could question his passion, sense of purpose, or his powerful rhetoric employed in the search for justice. Also consider this. For over 3 decades, his decisions on the death penalty have permitted Massachusetts to avoid the travails, travesties, and terrible price exacted by the use of the death penalty, suffered by other states, including Illinois, which only last month ended its legal experiment after more than 10 of its citizens were exonerated from death row. So these were a few of the many lessons that I learned during my time in law school and since. You might ask, how did I apply these lessons? Starting before the decision of the United States Supreme Court in Batson versus Kentucky, I represented Leo Edwards, a black man from my hometown of New Orleans, who had been sentenced to die by an all-white jury for the killing of a white person in Jackson, Mississippi. We alleged that the prosecutors in Mr. Edwards' case systematically eliminated qualified black jurors from service in capital cases. We thought that this was an extreme case, Mr. Edwards' case, that it might even satisfy the very difficult standard of Swain versus Alabama, requiring a showing that prosecutors were responsible for removing almost all the black jurors in every type of case. We were permitted to review the prosecutor's files, including hundreds of cases, and found jury selection sheets that listed the names of potential jurors with the B for black and W for white marked next to their names. We were able to quantify cumulatively all of these peremptory strikes and found that the prosecutor had struck over 80% of the qualified black jurors, while just approximately 20% of the qualified white jurors. We hired an expert statistician to evaluate that data, and the expert opined that the chances of that happening random were less than 1 in a million. Even more importantly, we had direct evidence from a very surprising source, and that was from the prosecutor himself. The elected district attorney, Ed Peters, informed us in a deposition that he indeed used race as a criteria for striking black jurors. He said that blacks were opposed to law enforcement and did not have a sufficient stake in society, so they would be prone to vote to acquit defendants. He said his philosophy was to strike as many black persons as he could from serving on jurors, and that he carried out that philosophy specifically in Leo Edwards' case. So what happened to Leo Edwards? He lost in state court, and the federal courts declined to apply Batson versus Kentucky to his case because of a technicality. Mr. Edwards' case had been final at the time Batson was decided. The federal courts applied Swain versus Alabama, but said we had not shown that no black person ever served on juries in Jackson, Mississippi, and we had not shown that. Finally, the court ignored the admission of race discrimination by prosecutor Ed Peters. As a historical note, the judge who wrote the decision denied relief to Leo Edwards, and the U.S. Court of Appeals for the Fifth Circuit had as a lawyer represented the state of Mississippi in its efforts to keep James Meredith out of the University of Mississippi in the early 1960s. Leo Edwards was executed by lethal gas in 1989 on the 25th anniversary of the murders of civil rights workers Schwerner, Cheney, and Goodman in Philadelphia, Mississippi. I witnessed the torturous and prolonged execution of Leo Edwards and have not witnessed another execution since. That same year, I moved to Mississippi, to North Carolina with my wife, who I'm pleased is here today to listen to this. I represented many death row inmates since 1989, and I filed many strong claims of race discrimination in the selection of jurors by the prosecutor's use of peremptory strikes. None have succeeded, however. In fact, in North Carolina, in the 25 years since the U.S. Supreme Court's decision in Batson versus Kentucky, only one criminal defendant's case has been reversed based on Batson in North Carolina. In other southern states, except Tennessee, reversals are much more common based on Batson. I don't think that is because there's less discrimination in jury selection in trials in North Carolina. In a recent report, the Equal Justice Initiative describes continuing and rampant race discrimination in jury selection procedures across the South. And you can find that report at www.eji.org. I also believe that race has played a significant role in decisions to seek or to impose the death penalty in North Carolina. But since 1987, when the U.S. Supreme Court decided McCluskey versus Kemp, there's been no way to prove it. In McCluskey, the court rejected the use of statistics as a means to show race discrimination in capital cases as a violation of the Equal Protection Clause. According to the McCluskey court, you must show that race discrimination happened in your particular case. In the 24 years since that decision, almost no one has been able to meet that standard. Michelle Alexander discusses the extreme difficulty of meeting that standard, not just in capital cases, but also in all criminal cases in her excellent book, The New Jim Crow. The McCluskey Court left the door open just a little bit by inviting legislatures to pass laws permitting the use of statistics as a way to prove race discrimination. In 2009, 20 years after I moved to North Carolina, I had the privilege to work with a coalition of groups to help pass a landmark bill, the North Carolina Racial Justice Act, that would address the problems in the enforcement of prohibitions against race discrimination left in the wake of Batson versus Kentucky and McCluskey versus Kim. The immediate impetus for the passage of the Racial Justice Act was the exoneration of 3 African American men from death row in North Carolina in the 2 years prior to the passage of the Racial Justice Act. The North Carolina Racial Justice Act generally states that no person shall be subject to or given a sentence of death or shall be executed pursuant to any judgment that was sought or obtained on the basis of race. To establish a claim under the Act, defendants in death penalty cases must show one of 3 things at the time his or her death penalty was sought or imposed. First, death penalties were imposed significantly more frequently by race of defendant. Second, death penalties were imposed significantly more frequently by race of victim, or that race was a significant factor in decisions to exercise parental challenges. The Racial Justice Act allows the use of statistics, and in addition to statistics, allows broad categories of evidence to be considered in support of and in rebuttal of claims. You are able to present under this Act evidence in varying geographic configurations by district, county, division, or by the entire state. Finally, the remedy, if the court finds a violation of the Racial Justice Act, is so that the death row inmate is resentenced to life without possibility of parole. That act was passed in August of 2009, and since then there's been considerable investigations and there's been considerable motions filed in most of the death penalty cases in North Carolina. There have been statistical studies that have found statewide persons with white victims were more than twice as likely to be sentenced to death as persons with African American victims. This was hardly surprising since prior studies from North Carolina and all across the country have demonstrated the same types of disparities. As a rule, in capital cases, white lives are treated as more precious than black lives. What was surprising was the systematic way in which qualified black citizens continue to be excluded from jury service in capital cases. Statewide prosecutors strike over twice the percentage of black jurors as compared to their strikes of white jurors. For persons currently on death row, 31 had all-white juries, and 38 had juries composed of just 1 person of color. Over 40% of persons currently on death row had either all-white juries or just a single person of color. We have discovered evidence of race discrimination in particular counties, and I'll just give you one example. In Johnson County, which had until about 15 years ago a sign placed at the border of the county saying "Home of the Klan," we found that in 100% of the black defendant capital cases, juries had returned the death penalty, but in just 40% of the white defendant cases, the juries returned the death penalty. We've also presented evidence in courts of discrimination in individual cases. For example, Guy LeGrand is an African American defendant who was convicted and sentenced to death by an all-white jury. Mr. LeGrand's 2 equally culpable or more culpable white co-defendants were allowed to plead guilty to second-degree life or simply were not prosecuted. One of those co-defendants hired Mr. LeGrand to kill his wife and referred to LeGrand as, quote, the nigger from Wadesboro. LeGrand represented himself and was so severely mentally ill that he wore a Superman t-shirt and in closing argument asked the jurors to kiss his natural black ass in the showroom of Helen Myers. If that's not enough, he's so mentally ill that the North Carolina State Court found him to be incompetent to be executed. And yet, he still resides on death row. The prosecutor's office that prosecuted Mr. LeGrand prosecuted several other capital cases, and in most of those cases, they obtained all-white juries. The district attorney in that district handed out noose lapel pins to his assistants who successfully prosecuted capital cases. In closing argument, the prosecutor in Mr. LeGrand's case analogized the proof to the thread of a rope being twisted together, again suggestive of a noose. For those who believe that the Racial Justice Act is not needed, consider that Guy LeGrand previously raised all of these claims of race discrimination in state and federal court, but he lost. The Racial Justice Act is his only hope of getting off of death row. What is the current status of the Racial Justice Act? The statute was found constitutional by a state court judge despite the DA's argument that the Racial Justice Act represents the end of Western jurisprudence as we know it. Recently, the first person has obtained relief under the Racial Justice Act in Durham, North Carolina, although the prosecutor used other reasons and the judge adopted other reasons for granting him relief, a person who had been through all of his appeals. So we're very excited about that fact. That happened only a few weeks ago. There's been political fallout from the Racial Justice Act. At the last election, there was a Republican Party flyer that distorted the bill. According to the flyer, a defendant who had committed a heinous crime could be moving next door to you as a result of Representative fill-in-the-blank's vote. And they had pictures of two of our clients on this flyer, and they described their crimes. However, the only remedy under the Racial Justice Act is life imprisonment without possibility of parole. So no one is going to be moving next door to any voter. And an interesting aside, one of the representatives targeted by the flyer, Representative Holland, had a daughter who had been murdered years earlier, and the murderer had been executed. Representative Holland supported the death penalty and supported the death penalty for the murder of his daughter. But he also supported the Racial Justice Act, and he said, I believe in the death penalty, but I believe it should be fairly administered, and the Racial Justice Act is an important safeguard that we need to continue to use the death penalty. But you can imagine his feelings when he saw this flyer distributed in his district and targeted against him. Representative Holloman lost his election, as did a couple of the other people targeted on this flyer. The legislature has since changed hands. The Republican Party in North Carolina is now in the majority in the House and the Senate, and there's a repeal bill proposed for the Racial Justice Act. And that's something we will do our best to try to defeat. Despite the political fallout from this law, or maybe because of it, when I think of North Carolina's Racial Justice Act, I can perhaps see Justice Bianco's spirit looking on approvingly at what North Carolina has accomplished, and perhaps smiling. Thank you.
Means of discovery under the Racial Justice Act. How do you gather information about disparities? Do people have to keep records? of the race of potential jurors who are here. You have the right to take depositions, to discover prosecutorial records.
It was between the passage of the Act in August 2009 and the filing of the first pleas, which were required to be filed within a year after the passage of the Act. It was a huge effort made by our experts from the Michigan State University Law School to gather information and identify race of jurors, for example. And they used a lot of different sources. The first source, and probably the most reliable source, was juror questionnaires, which often, if not always, in North Carolina, identify the race of the jurors. Then they self-identify. So the jurors, in most of the cases, fill out these questionnaires and fill out their race. If we couldn't get it from that means, there were a lot of other search vehicles, such as voting registration lists, driver's license lists, and sometimes just private search vehicles that were able to identify race in that way. They used publicly available documents from the clerk's offices all around the state. They had a team of about at any one time, 20 to 30 people, mostly law school graduates, including one BU law school graduate, Alex Nicely, who worked on this study. And they would say that it was not done by the year, but they did a hell of a job and gave us support for our claims, not just statewide, but by county and by district. So it was an amazing job done by these experts. And they looked at, as I've said, they looked at perjury strikes and they looked at charging and sentencing. It required a huge effort.
Could you talk about whether or not this legislation that you said was passed impacts the work of the North Carolina Innocence Inquiry Commission, or if they work in tandem, or
Yeah, for those of you who are unaware of it, the North Carolina Innocence Inquiry Commission is the first of its kind in the United States. And what it does is it sets up an office that investigates claims of innocence, of actual innocence. And in order to get relief under this act, you have to show that you did not commit the crime, and you have to waive some of your rights, including your Fifth Amendment right not to incriminate yourself. So that was passed before the Racial Justice Act, and it's really unrelated. So far, under the North Carolina Actual Innocence Inquiry Commission has found one person to be actually innocent as they do their process, and it's an interesting process because it allows victims, district attorneys, and law enforcement to participate in decisions on whether or not the person is actually innocent. So in a political sense, it's weighted against the finding of actual innocence. And that's most likely the reason why there's only been one person so far that's been found actually innocent by the commission.
With respect to all of these objections you're raising against capital punishment, juries, and these other technicalities, let me just understand you correctly. No matter what the evidence is in any case, no matter if a guilty plea is forthcoming, no matter how absolutely positive 100% somebody is guilty, you are still against capital punishment. Is that correct? No matter what the evidence. And on that piece of clarification, is Elie Wiesel, was he against the Nuremberg decisions in hanging those Nazis, and also Adolf Eichmann, was he against them being executed? And also were you against the results of the Nuremberg trials?
Okay, I'll try to take one at a time, if I might. Yeah, I personally am against the death penalty. I think the reason I'm against the death penalty is because in the 30 years that I've done this work and in the things that I've seen, I do not believe that we can do it fairly, that we can get the right people, that we can protect innocent people who are caught up in the system. And as a system, we haven't figured out how to do it in a way that protects people and gets the right people. And I have seen, and I've represented persons on death row who were in fact innocent and have been exonerated. And I know, I strongly believe that we have executed innocent people. I know race is a factor in our choice of who lives and who dies in the use of the death penalty. I know that there are good prosecutors, there are good defense attorneys, but I also know that they make mistakes. And I do not want to put people's lives on the line when I know that those mistakes have occurred and are still occurring. So my answer to you is that if we could devise a system, and I don't think the system that Governor Romney devised in Massachusetts fits that bill, but if we could devise a system that got the right people, was fair, was non-discriminatory, then I might consider whether the death penalty should be used. But we are not there, and I don't believe, in my experience, that we will be there. In terms of Elie Wiesel, I know of his speech. I know what he said in August 2010. I can't speak for him, so I don't know how he felt at the time of the Eichmann trial or how he felt at the time of the Nuremberg trials. I personally feel that, again, that we don't have a system that works fair enough and gets the right people often enough to satisfy any debt.
Well, Ken's going to be here meeting with students, right?
Yeah.
Thank you very much. And so we have a little time now for a reception, and Ken will be here if you want to chat with him